Imagine you're at a shopping mall.
Yeah.
It's a Saturday afternoon. The place is packed.
Yep.
You're there with two of your friends, just, killing time. Maybe you're near the food court. You get into a shouting match with another group of guys. Maybe it's over a girl, maybe over a pair of sneakers. It doesn't really matter.
A totally normal, stupid situation.
Exactly.
Yeah.
One of your friends throws a punch. No weapons, just a fist. It's a scuffle. In a normal world, that is a misdemeanor assault.
Right.
Maybe a night in the drunk tank, maybe some probation.
Yeah.
It's bad, but it's not, life-ending.
But in Texas, if the wrong prosecutor picks up that file and decides to apply the statutes we're looking at today, that little scuffle, it could effectively be the end of your life as you know it.
Welcome back to the Deep Dive. Today, we aren't just reading the law. We're decoding a trap. We are looking at Texas Penal Code, Chapter 71, organized crime statutes. And I want to be really clear right off the bat. This is not just for people with neck tattoos and, extensive rap sheets. This is a legal net so wide it can catch the shark, the minnow, and the guy just standing on the dock watching the water.
It is the web of three. I think that's the concept we really need to drill into your heads for the next hour or so. The gap between what you think organized crime is.
That's the movies, right? The Godfather, the Blood Oaths.
Exactly. That and what the state of Texas actually defines it as.
Oh.
Well, that gap is where people go to prison for decades.
We're going to unpack exactly how that net works. But before we unravel this web, I have a job for you. Yes, you. Listening right now.
It's an important one.
It really is.
Yeah.
If you want us to keep navigating these legal minefields, if you want us to keep translating these incredibly dense legal statutes into plain English that might, actually save your bacon one day, please hit that subscribe button.
Right now.
Right now. It really does support the show. It helps the channel grow. And honestly, the knowledge in this deep dive alone is worth the click.
Absolutely. It ensures you don't miss the next one, and it helps us find more source material like this to break down for you.
Also, head over to our website. We've got resources, links to the actual statutes we're discussing today, and some great visual aids that can help this all stick. Okay, housekeeping done. Let's look at the source material.
We are diving into the black and white text of Texas Penal Code Chapter 71.
And our mission, as you put it, is to dummy down the law.
And I don't mean that in a derogatory way at all. I mean, we need to strip away the Latin, strip away the courtroom jargon, and really look at the mechanics.
The nuts and bolts.
Exactly. We need to understand how the law defines a gang, what a combination is, and most importantly, why committing a crime with two of your buddies is legally catastrophic compared to doing it alone.
That's the why this matters part, isn't it? Because I think most people, myself included, assume organized crime charges are reserved for, the mafia.
The cartels, the Yakuza.
Right. Massive international syndicates meeting in dark warehouses.
That is the common misconception. But as we go through this, you are going to realize that organized crime in Texas can apply to a surprisingly small group of people committing what seem like fairly common crimes. The threshold is it's so much lower than people think.
And here's the teaser that absolutely floored me when I was reading the notes, and we will get into the details of this shortly.
Yeah.
You don't even have to know the names of the people you're technically conspiring with to get charged.
That is correct. You can be total strangers and still be co-conspirators in the eyes of the law.
That is genuinely terrifying. Okay, let's unpack this. Segment 1, the magic number. We need to define this thing they call a combination.
This is the foundation, section 71.01a. Everything builds on this.
So in my head, an organized crime ring is like 50 guys. It's a hierarchy. There's a boss, an underboss, captains, soldiers, a whole pyramid structure.
The Sopranos model.
Exactly. Yeah. So what is the actual legal threshold in Texas for a combination?
3.
Wait, just 3?
3 or more persons? That's it. If you have yourself and 2 friends and you collaborate in carrying on criminal activities, you've met the numerosity requirement for a combination.
So if me, you, and our producer decide to go steal hubcaps from cars in the parking lot, that's potentially organized crime.
Potentially, yes. It depends on the continuity and the intent, which we'll get to. But the number 3 is the floor. It's the magic number.
Why 3? Why not 2 or 4?
Well, 2 people is just a partnership or a co-defendant situation. It's simpler. But the moment you add that third person, the law presumes a level of sophistication, a level of organization that it believes triggers a greater danger to the public.
So it's not just a duo, it's a group.
It's a group. And that's what scares the legislature. So 3 is the line in the sand.
Okay, and the definition of combination in Section 71.01a is where things get really, really sticky. It says 3 or more persons who collaborate in carrying on criminal activities. But then it lists these 3 conditions that do not disqualify you. It's like the law is anticipating your excuses.
That's exactly what it is. It's shutting down defense arguments before a lawyer can even make them. Let's look at the first one. Section 71.01a1.
Participants may not know each other's identity.
This is what I call the stranger rule.
Okay, hold on. I have to play devil's advocate here. How can I possibly be in a criminal combination with someone if I don't even know who they are? How can we collaborate if I don't know your name?
It's a great question. Let's use an analogy from the legitimate world. Think about the modern gig economy, like a food delivery app.
Okay.
You order a burger on your phone. The restaurant cook, let's call him Bob, he makes it. A driver, Sarah, she picks it up. You eat it. You don't know Bob's last name. Bob has no idea who Sarah is. Sarah only knows you as John D.
Right. We're all complete strangers.
But you are all collaborating. You are a functional unit designed to move that burger from point A, the kitchen, to point B, your mouth.
I see where this is going.
Now, strip away the burger and replace it with, say, a kilo of cocaine. The cook is the supplier in Colombia. The driver is the mule or the courier who brings it over the border. You're the street dealer who's distributing it in a city. You have never met the supplier. You might not even speak the same language. You certainly don't know the courier's real name, maybe just a handle on an encrypted app.
But we're all part of the same process.
You're all part of the same machine. And the law says your ignorance of the other person's identity is not a defense. It doesn't matter. The prosecutor doesn't care if you're best friends. They care if you are functional pogs in the same criminal mechanism.
It effectively treats the criminal enterprise as a single organism,
Right.
rather than just a collection of individuals.
Precisely. Which leads us to the second point, subsection 2.
Membership in the combination may change from time to time.
This is the revolving door rule, or, if you prefer, the sports team analogy.
Explain that one.
Okay, let's say you have a group stealing cars, a chop shop ring. You have 3 people. One guy, Steve, gets arrested. So you recruit a new guy, Mike, to strip the engines. Then another guy quits because he's scared, and you want in someone else, a woman named Jenny, to drive the tow truck. The defense attorney can't stand up in court and say, Your Honor, this isn't the same combination anymore because Steve left and Mike joined.
It was the Steve gang, but now it's the Mike and Jenny gang.
The law says no. Think of it like a sports team. The roster of the Dallas Cowboys changes every single season. Players retire, new players get drafted, people get traded, but it is still the Dallas Cowboys organization.
The entity remains.
The combination persists even if the faces change. As long as the criminal activity continues and the structure, however loose it is, remains, the combination exists.
That really cements this idea that the combination is an entity separate from the people in it. It's a legal ghost.
It is. And then we get subsection 3, which I think is probably the most nuanced and dangerous one. Participants may stand in a wholesaler, retailer, or other arm's-length relationship in illicit distribution operations.
The retailer rule. Break that down for us, because normally, buying something from a store doesn't make you partners with the store.
Exactly right. In the legal world, usually a buyer and a seller are on opposite sides of a transaction. If I buy a used car from you, we aren't partners. We're adversaries in a way. I want the lowest possible price. You want the highest price. We're at arm's length.
Our interests are opposed.
But in the world of illicit distribution drugs, stolen goods, weapons, this statute completely collapses that distinction. The law says that even if you are just the retailer buying from the wholesaler, you are part of the same combination.
So to use a supply chain analogy, if I go to the grocery store and buy a loaf of bread, I'm not in a combination with the truck driver who brought it or the guy at the factory who baked it.
Correct.
But if that loaf of bread is a brick of heroin,
then legally, under Texas law, you, the truck driver, and the factory worker are all holding hands in a combination. You are all linked. The law removes the I was just a customer or I was just a middleman excuse. It basically says that by participating in the illegal market, you are participating in the criminal organization.
That is wild. It just casts such an incredibly wide net.
It's designed to. Now, we have to couple all of this with the definition of conspiracy in Section 71.01b, because you hear that word all the time. Conspiracy theories, conspiracy to commit murder. But in this specific legal context, what is the equation?
From the notes, it looks like a really simple formula. Agreement plus an overt act.
That is the formula. It's that simple and that complex. First, you need an agreement between one or more persons to engage in conduct that would be a crime.
Okay, but does that agreement have to be written down? Do we need a contract signed in blood? Do I have to have a recording of me saying, I hereby agree to rob the bank?
Absolutely not. And this is where so many people get caught. This statute explicitly says an agreement constituting conspiring to commit may be inferred from the acts of the parties.
Inferred from the acts.
Yeah.
That sounds like a trap.
It means the jury can look at your behavior and work backward. If we look at what you did and it looks like you agreed, the jury's allowed to assume you agreed. You don't need a secret recording.
So actions speak louder than words.
Much louder. If you drive the getaway car and I run into the bank with the bag, and our friend holds the door open, our acts infer the agreement. The coordination is the proof of the agreement.
And the second part, the overt act.
Someone has to take a substantial step. You and your friends can sit around and talk about robbing a bank all day long. You can fantasize about it. That's generally protected speech or just, thought.
Right.
But the moment one of you goes out and buys ski masks or scouts the bank and draws a map or steals the getaway car, that is the overt act.
Even if you haven't actually robbed the bank yet.
Even if you are miles away from the bank and days away from the plan, buying the masks is the overt act that proves the conspiracy is now live. The clock has officially started.
So we have the combination, the three people. We have the conspiracy, the agreement, plus the act. Now let's talk about the labels, because the statute distinguishes between a combination, a criminal street gang, and a foreign terrorist organization.
Right. And this is important because these different labels trigger different penalties, different enhancements, and different public safety tools for law enforcement.
Let's start with the criminal street gang. Section 71.01, D-Gang. How is this different from just three guys who decide to commit a few crimes?
It builds on that same foundation. It still requires 3 or more persons, so the magic number is still in play, but it adds 2 specific criteria that elevate it from a simple combination to a gang.
Okay.
First, they must have a common identifying sign or symbol or an identifiable leadership.
So this is where the movie stuff comes back in. Colors, tattoos, hand signs.
Exactly.
Yeah.
If everyone in the group has the same tattoo of a spider on their neck or wears a specific color bandana or uses a particular hand sign, that's the sign or symbol.
Oh, the identifiable leadership.
Right. If everyone in the group answers to one person, let's call him Big Tony, that's the identifiable leadership. There's a structure.
And the second criteria.
That they continuously or regularly associate in the commission of criminal activities. A combination could be a one-off thing. Me, you, and the producer steal hubcaps one time. We're a combination.
Okay.
But a gang implies a pattern of association, a criminal lifestyle.
So if we steal hubcaps every Tuesday,
Yeah.
and we all wear matching red hats while we do it.
Now, you're a criminal street gang in the eyes of Texas law.
Hmm.
And the penalties and the way you're treated by the system will reflect that shift in status.
Okay, then we have the foreign terrorist organization in section 71.01E. This feels like it was written for a very specific purpose.
It absolutely was. Again, it starts with 3 or more persons. But here, the first key requirement is that they operate at least partially outside the United States.
Got it. Cross-border.
Cross-border. And second, they engage in criminal activity that threatens the security of this state or its residents. Now, look at the text of the statute very closely. It gives a specific example.
I see it right here. Including, but not limited to, a drug cartel.
Texas law does not mince words here. It explicitly gives the state the power to categorize drug cartels under the definition of foreign terrorist organizations if they meet those criteria.
So it's not just a crime, it's a security threat.
It allows the state to reframe the drug trade. It's not just a crime problem, it's a security problem, which then allows them to use the heavy artillery of the penal code against these cross-border trafficking operations.
So whether it's a combination, a gang, or a terrorist org, the law is obsessed with that number 3 and with the idea of collaboration. It is the web of 3.
It is. The legislature has made a decision that crime is exponentially more dangerous when it is organized. A single burglar is a nuisance. 3 burglars working together are a systemic threat to the social order. Because they can do more damage, they can evade capture better, they can intimidate witnesses more effectively. So the law comes down on them much, much harder.
Which brings us to the real meat of the statute, section 71.02. Engaging in organized criminal activity.
Right. Lawyers and cops will call this EOCA, or just engaging. If you hear a lawyer say, he got picked up for engaging, this is the statute they mean.
EOCA. Okay, so I have the intent to establish or participate in a combination, but I actually have to do something, right? I can't just exist as a group of three.
Correct. You have to commit or conspire to commit one of the offenses that is listed in Section 71.02a. And this list is massive. It is what we call a laundry list statute. It just goes on and on.
I was reading through this list, and some of it is exactly what you'd expect, the heavy hitters, you know.
Of course. Murder, capital murder, arson, aggravated robbery, kidnapping, the most violent, high-stakes crimes. That makes perfect sense. If you organize a group to commit murder, that is clearly organized crime.
Drug distribution is in there, too. Unlawful manufacture, delivery, dispensation.
Of course. The drug trade is inherently organized. You can't run a drug empire by yourself.
But then I started hitting the surprises. The stuff where I had to stop and think, wait, really? That's in here.
Oh.
And I want to stop on one specifically because it feels like such an outlier.
What stood out to you?
Unauthorized use of a motor vehicle. UMMV.
Ah, yes. What most people call joyriding.
Yeah. Why is joyriding in the organized crime statute? That sounds like a couple of teenagers being idiots, not the Sopranos running an operation.
This is where you have to take off your civilian hat and think like a prosecutor or a detective. Think about the logistics of professional crime.
Sure.
If you were going to commit a drive-by shooting or a bank robbery or a home invasion, are you going to use your own car, the one that's registered to your home address with your own license plate?
No, of course not. You'd use a stolen car.
Exactly. Or what they call a switch car. A car that is clean, meaning it's not tied to you, but dirty in the sense that it is stolen. The unauthorized use of a motor vehicle is the first step in the supply chain for a more violent crime.
So the UMV is a tool for the combination.
Precisely. Gangs will often have lower-level members initiates, or peewees as they're sometimes called, go out and steal cars specifically to be used in later felonies.
So let's play out a scenario. Police catch a kid in a stolen Kia. He hasn't had a drive-by. He's just driving around in a stolen car. Normally, what is that charge?
Normally, unauthorized use of a motor vehicle is a state jail felony. That means 6 months to 2 years in a state jail facility. He might even get probation if he has a clean record.
Okay, manageable.
But if the district attorney can prove that he stole that car for the benefit of the combination because the gang leader told him to do it, or because it was destined for a chop shop operation run by the gang, now we trigger engaging in organized criminal activity.
And the punishment changes.
It does. That state jail felony automatically bumps up one category to a third-degree felony.
Now he's looking at 2 to 10 years in prison.
For a car theft. With context. The law is punishing the potential of what that car was going to be used for. It allows the state to intervene and drop the hammer before the drive-by actually happens.
That makes a scary amount of sense when you frame it that way. It's not just teenagers taking a car for a spin. It's a logistical tool for the combination.
Right. And chop shops are the other big reason. You have a group of people, 3 or more, stealing cars to strip them for parts and sell them. That is, by definition, an organized criminal enterprise. So UMV is included to catch those rings.
Okay, what's another surprise on this list?
How about any gambling offense punishable as a Class A misdemeanor?
So like a backroom poker game.
Exactly. Gambling has historically been the bread and butter of traditional organized crime. Bookmaking, illegal casinos, numbers games. It generates untraceable cash that can then be used to fund other activities. So if you have 3 guys running a regular poker room in the back of a bar, that could be a combination.
And then there's forgery.
Think about it. Fake IDs, fake checks, money laundering operations. You can't run a sophisticated criminal ring without some kind of fraudulent paperwork. This allows them to prosecute the people who create the documents, not just the people who use them.
And even assault punishable as a Class A misdemeanor. That's like a bar fight, isn't it?
It can be. A simple punch that causes pain. But in the context of a gang, it's often an initiation beating or a way of enforcing territory or collecting a debt. If 3 gang members jump someone and beat them up, even if they don't use weapons, that's a Class A assault. But because they did it as a group, under Section 71.02, it becomes EOCA.
And then there are the catch-alls. This list references other entire chapters of the Penal Code.
Yes. It pulls in Chapter 20A, which is human trafficking. It pulls in Chapter 35A, which is Medicaid fraud. And it even includes any offense classified as a felony under the tax code.
The tax code, they really did think of everything.
Remember Al Capone? They got him on taxes. If you were running a sophisticated scheme to defraud the state of tax revenue fuel tax fraud, is a big one in Texas, that can be charged as organized crime.
And finally, before we move to punishments, there's this concept of profits in Section 71.01c.
This is a crucial piece. It's defined as property constituting or derived from any proceeds obtained from an offense. Basically, if you are in the combination just to hold the money or you are participating in spending the profits, you are on the hook.
So I don't have to be the one who smashes the window of the car to steal the stereo.
No. If you are the one who takes the stereo to the pawn shop, or if you're the one spending the money from the pawn shop and you know where it came from, you're in. It's designed to catch the money launderers and the financiers.
Okay, so we've defined the group, the combination. We've defined the acts, the laundry list. Now let's talk about the consequences, because this is where the hammer really, really drops. Section 71.02b.
This is the multiplier effect. The statute says, in simple terms, that if you commit an offense as part of a combination, the punishment is one category higher than the punishment for the crime itself.
One category higher. Let's dummy that down. What does that mean in real terms? Walk us through the math on that.
Okay, let's take that Class A assault we talked about.
Yep.
3 guys, beat someone up, cause some pain. Normally, a Class A misdemeanor gets you a maximum of 1 year in the county jail.
1 year. That's bad, but it's not life-ruining.
But if the DA charges it as engaging in organized criminal activity, that Class A misdemeanor gets bumped up 1 category to a state jail felony.
And a state jail felony carries
180 days to 2 years in a state jail facility. But, and this is the huge part, you are now a convicted felon. You lose your right to vote while on paper. You lose your right to own a gun forever. You can't get certain jobs, certain professional licenses. The stigma is permanent.
All because you did it with 2 friends instead of 1.
That's the difference. Now let's move up the ladder. If the underlying crime is a 3rd-degree felony, normally punishable by 2 to 10 years in prison.
It becomes a 2nd-degree felony.
Right. And now you're looking at 2 to 20 years. If it's a 2nd-degree felony, it becomes a 1st-degree felony.
And a 1st-degree is
5 to 99 years. Or life in prison. So this statute can literally add decades to a sentence.
It's a way to create leverage.
That's exactly what prosecutors want. They want leverage to get plea deals, to get people to flip on each other. When you are facing 20 years instead of 10, you start thinking very differently about loyalty.
And there are some situations where it goes straight to the maximum penalty, right? It doesn't just bump up 1 level.
Yes. There are specific enhancements within the statute that take you straight to the top. They show zero mercy.
I saw that about aggravated sexual assault.
Section 71.02b1. If the underlying offense is aggravated sexual assault and the victim is younger than 6 years old or younger than 14 with specific aggravators, it's life without parole, period. The statute shows zero mercy for organized predation on children.
And then there's the deadly weapon finding.
Yeah.
That's Section 71.02e. How does that work?
This is the floor raiser. If anyone in the combination uses or even just exhibits a deadly weapon during the commission of the offense, it affects your eligibility for parole.
In what way?
Normally, you might be eligible for parole after serving a quarter of your sentence. With a deadly weapon finding, you have to serve half of your actual sentence day for day before you are even eligible to ask for parole. It ensures that armed organized crime is treated with extreme severity.
Okay, so if you are the foot soldier, the guy on the street, you get bumped up. What about the boss? What if you're the guy in the nice suit who never touches a gun or a bag of drugs?
That brings us to Section 71.023, directing activities of criminal street gangs or foreign terrorist organizations.
This is the kingpin statute.
That's exactly what it is. It targets the identifiable leadership we talked about earlier. The requirement is that you knowingly finance, direct, or supervise the commission of a felony.
Finance, direct, or supervise.
Notice what's missing from that list. Commit. You don't have to commit the robbery. You just have to pay for the van.
Or tell them which bank to hit.
Or supervise the counting of the money afterwards. If you're the brain, you're on the hook.
And the punishment for being the brain.
It is a felony of the 1st degree, but it's a special kind. It's punishable by imprisonment for life or for any term of not more than 99 years or less than 25 years.
Whoa, wait. The minimum is 25 years?
Correct. For most 1st-degree felonies in Texas, the minimum is 5 years. You could technically get 5 years probation in some very rare cases, but for this specific statute for directing a gang, the floor is 25 years. No parole eligibility until you've served a huge chunk of that.
So if you write the check to fund the operation, you are looking at a quarter-century minimum.
Yes. Even if the underlying crime failed. Even if it wasn't a violent crime. If you directed a felony as a gang leader, you are gone for 25 years. It's a statute designed specifically to cut the head off the snake.
And speaking of growing the snake, let's talk about recruitment. That's section 71.022.
Coercing, inducing, or soliciting membership.
Is it actually a crime just to ask someone to join a gang?
If membership in that gang requires breaking the law, yes. The statute makes it a crime to knowingly cause, enable, encourage, recruit, or solicit another person to join if, for example, the initiation requires you to commit a crime.
So the whole jump in, blood out, if that's the requirement, the recruiter is committing a felony just by making the offer.
A third-degree felony, just for the speech act of recruiting someone into that leg.
But it gets much worse if kids are involved.
Much, much worse. Subsection A1. If you intend to coerce, induce, or solicit a child, which is defined as younger than 17, to participate, and you threaten them or their family with bodily injury.
Which happens all the time. Join, or we're going to beat up your little brother. Join, or we're going to burn your mom's house down.
Precisely. If you do that, or if you actually cause bodily injury to the child or their family to get them to join, it's a separate, enhanced offense. And notice, family is defined very broadly by the Family Code. It's not just mom and dad. It can be an aunt, an uncle, a cousin.
It effectively weaponizes the recruiting process against the recruiter.
It acknowledges that gangs thrive on fear. They don't just offer camaraderie, they offer an ultimatum, and this statute criminalizes that ultimatum.
Okay, we've covered the who, the what, and the punishment. Now let's talk about the where, because this is the part that I think affects the average listener the most, even if they're not in a gang. Gang-free zones.
Section 71.028. This is all about geography. The law creates invisible bubbles around certain places.
We all know about school zones. You sell drugs near a school, the penalty goes up. That's pretty standard across the country.
Right. And this statute includes those. Schools, institutions of higher education, playgrounds, youth centers. The buffer zone there is 1,000 feet.
1,000 feet, that's about 3 football fields. A pretty big area.
It is. But then the statute lists a second category of locations with a 300-foot buffer. And these are the ones that catch people completely off guard.
I was really surprised by this list.
Shopping mall, movie theater, video arcade facility.
A shopping mall.
Yes. The definition is an enclosed public walkway or hall area that connects retail, service, or professional establishments.
So let's think about 300 feet. Is that 300 feet from the door of the mall or from the property line?
It's usually measured from the property line, so that includes the entire parking lot plus a football field's length in every direction out into the surrounding streets and businesses.
So let's say I'm in a combination, me and my 2 idiot friends. We're in the parking lot of a mall, and we're selling some stolen hubcaps. We aren't in the mall, we're just near it.
You are inside a gang-free zone. And that punishment ladder we just talked about, everything goes up another rung.
So a 3rd-degree felony becomes a 2nd degree, a 2nd becomes a 1st.
Exactly. It's another multiplier. And here's the kicker. It doesn't matter if you knew the mall was there. What if it's nighttime and you can't see the sign?
I was going to ask that.
The statute doesn't require you to know you were in the zone. It operates on strict liability for your location. If the map says you were there, you were there. Ignorance is no excuse.
And the video arcade one? I mean, did those even exist anymore?
The definition in the law is any place open to the public that is intended primarily for the use of pinball or video machines.
That's a Dave & Buster's. That's a Chuck E. Cheese.
That's exactly what it is. So if you are a gang member and you decide to settle a beef in the parking lot of a Chuck E. Cheese, you have just walked into a sentence enhancement trap. The legislature is trying to create safe havens for young people.
And how do they prove you were in the zone in court? Do they bring in a guy with a tape measure?
They used to have to do that, but not anymore. Section 71.029, maps as evidence.
This sounded like a cheat code for the prosecution when I read it.
It practically is.
Yeah.
The city or county engineer can produce an official map showing the boundaries of all of these zones, the school zones, the mall zones, the arcade zones, etc. If the governing body of the city or county approves that map, it becomes prima facie evidence.
Prima facie. That means?
It means on its face. The map is accepted as a proven fact. The prosecutor just has to hand the map to the jury and say, ladies and gentlemen, look, the crime happened here inside this colored line. The burden then shifts to the defendant to prove the official city map is wrong.
Which is very hard to do.
Usually impossible. So they literally map out the entire city into danger zones for criminals.
That is a very sobering thought. You could be walking down the street, think you're in the clear, but you're actually 290 feet from a movie theater you didn't even notice.
And that's enough. In a dense city like Houston or Dallas or Austin, if you overlay 300-foot bubbles from every strip mall, every theater, and every arcade, is there anywhere left?
Effectively, no. In an urban environment, you are almost always in a zone. The neutral ground doesn't exist.
Exactly.
Okay, segment 7. Is there any way out? Let's say you're caught in this web, the web of 3. What defenses actually work? And maybe more importantly, what defenses absolutely don't work?
Let's start with what fails, because the statute is very clear on this. Section 71.03 excludes the most common excuses.
The it's not fair defenses.
Basically. Let's look at subsection 2. It is no defense that one or more members of the combination have been acquitted, have not been prosecuted, or are immune from prosecution.
So if my 2 buddies have a great lawyer and they get off, or if they make a deal with the prosecutor and don't get charged, I can still be convicted of organized crime.
Yes. Your guilt is independent of their legal outcome. Even if they are found not guilty by a jury, the state can still prove that they were, in fact, part of the combination in your trial.
That feels completely counterintuitive. If a jury says they weren't criminals, how can I be in a criminal combination with them?
Because different juries see different evidence, or maybe their lawyer was better. The law prevents you from piggybacking on someone else's luck or their good legal victory.
And what about the changing roster we mentioned earlier, the revolving door?
Same thing, subsection 4. It is no defense that there's a change in the number or identity of persons. As long as 2 or more of the original people remain involved, the combination survives.
Okay. So arguing that everyone else walked free doesn't work. What about I refuse to talk? The Fifth Amendment.
That's where section 71.04 comes in. Testimonial immunity.
Can they force you to snitch on your friends?
The short answer is yes. The statute says a party to an offense under this chapter may be required to furnish evidence or testify.
But the Fifth Amendment? The right to remain silent.
The Fifth Amendment protects you from self-incrimination, so the state makes a trade. Subsection B says that no evidence or testimony you give under this requirement can be used against you in a criminal case.
Ah, so they give you immunity for what you say.
Correct. It's called use immunity. Once they grant you that protection, your Fifth Amendment right evaporates because you are no longer in danger of incriminating yourself. At that point, you must testify. If you refuse, you can be held in contempt of court and put in jail until you decide to talk.
So that's how they break the code of silence. They find the weakest link in the chain, give them immunity, put them on the stand, and force them to talk about the big fish.
It is the classic tool for dismantling criminal organizations.
But is there a way to get out before the handcuffs go on? Is there an escape hatch in this whole thing?
There is one, but it's a very narrow one. Section 71.05, the renunciation defense.
Renunciation. That implies quitting, walking away.
It implies a lot more than just quitting. It requires voluntary and complete renunciation. But I have to warn you, the door on this escape hatch is very heavy and very hard to open.
Okay, so I can't just ghost the group chat and move to another town.
Not even close. You have to withdraw from the conspiracy before the main crime is committed. That's the easy part. The hard part is subsection A. You must make a substantial effort to prevent the commission of the offense.
Prevent it? So I can't just walk away. I have to actively try to stop my friends from doing the crime.
Yes. You have to take an affirmative step. You have to call the police. You have to warn the intended victim. You have to sabotage the getaway car. You have to do something tangible to stop it.
Hold on. Let's look at the reality here. We're talking about organized crime. We're talking about gangs, cartels. If I call the cops on my crew to prevent the offense, I might save myself from a prison sentence. But
you're putting a massive target on your back. Absolutely.
So the law is literally asking you to choose between a long prison sentence or potentially getting killed for being a snitch.
That is the calculus. The law rewards you for flipping, for disrupting the combination, but it demands that you take a massive personal risk to do so.
And you have to be the one to prove you did it right.
Yes, it is an affirmative defense. That means the burden of proof shifts to you. You have to prove to the jury by a preponderance of the evidence that you really and truly tried to stop it.
I tried, Your Honor.
It's not enough. Show me the call logs to the police. Show me the text messages where you warned the victim. If you can't prove it with evidence, the defense fails. And if you only quit because you heard sirens coming down the street, that doesn't count.
Right, the panic rule. You can't renounce just because you got scared of getting caught at the last minute.
Section 71.05b. You can't renounce because of circumstances increasing the probability of detection. You can't renounce because you realize the bank has a new alarm system. And you can't renounce just to postpone the crime until next week when security is lighter. It has to be a genuine change of heart.
And if you somehow manage to prove all of that, what do you get? Do you get a gold star, a get-out-of-jail-free card?
You get a mitigation. The punishment for the offense drops 1 grade lower.
Wait, just 1 grade lower? You don't get off scot-free after all that?
Not necessarily. Remember, you might still have committed the conspiracy part just by agreeing and taking an early step. But the renunciation is an affirmative defense to the organized crime charge itself. If you're successful, it unwinds the enhancement. It takes you back down the punishment ladder.
That seems like a ridiculously high bar for only a partial reward.
It is. But in a world of life sentences and 25-year minimums, dropping from a first-degree to a second-degree felony can mean the difference between dying in prison and one day seeing your grandkids.
True. Context is everything. So let's zoom out. What does this all mean? What's the big picture here?
It feels like the state has built a machine designed specifically to amplify consequences. I think that's the perfect summary. Chapter 71 is an amplifier. It takes a base crime, a theft, an assault, a drug possession, and it plays it through a stack of Marshall amps cranked to 11.
And the only input signal it needs is collaboration.
Yes. The moment you involve others, the system assumes you are more dangerous, more efficient, and more of a systemic threat. So the penalties scale up dramatically to match that perceived threat.
And it doesn't matter if you are a cartel boss living in a mansion or 3 kids breaking into cars in a mall parking lot. The mechanics of the law, the web of 3, they apply to both.
The net is designed to catch everyone, from the financier writing the checks, to the recruiter, to the guy who just drives the car.
This has been incredibly eye-opening. I will never look at one of those drug-free zone signs the same way again, and I certainly didn't know about the movie theater rule.
It definitely makes you more aware of your surroundings and the invisible lines drawn all over our cities.
Here's a final thought for you to chew on, listeners. We talked about those maps, the zones, 1,000 feet from a school, 300 feet from a mall, a theater, an arcade. In a sprawling city or even a dense suburb, how much of the public space that we occupy every day is actually neutral ground?
It's a great question.
Are we walking through invisible legal minefields every single time we go to a shopping center and we just don't know it?
It effectively zones the entire city as an enhanced penalty zone.
Something to think about. If you enjoyed this deep dive into the Texas Penal Code, please, and I really mean this, hit that subscribe button. Leave us a review. It really helps us find more experts and cover more of these important topics.
And check out the website for the full text of Chapter 71 if you want to read it for yourself.
Always read the source material. Thanks for listening to the deep dive. We'll see you next time.
Stay safe